We're going to get started on our second presentation here. And it is my pleasure to introduce to you Kim Cessna, Vice President and Trust Department Manager, Beverley Chapman as Trust Administrative Officer, and Willie Sheehan, Attorney with Sheehan and Sheehan.
Okay. Thanks, Joe. Thank you. Again, my name is Beverley Chapman, and I, along with my friends Kim Cessna and Josh Purdy, represent the Bank of Springfield Trust Services Group. Thank you for taking time out of your afternoon to have it spent with us here. I know always the flowers out front are such a good draw and so beautiful to see, so I hope you got to enjoy those a bit. Kim, Josh, and I were all born and raised here in Springfield, and we have raised our own families here and continue to raise our fourth generation of families here. It truly is our home, and it's where we are proud to be, and certainly proud to be a part of the Bank of Springfield team. We have a wonderful turnout with all of you here again with us sharing today. We've been excited and a bit nervous all week, but it's so nice to see faces and smiles and people that you haven't seen for quite some time. Just out of curiosity, and I hope you take this lightly, but how many of you have a bit of fear or feel overwhelmed when thinking about your family's future after your death? It's quite significant. Yeah. It is. And you're not alone. It is a valid fear. And the concerns drum up a lot of emotions that often make us even more fearful of how do we begin this planning process. Our Bank of Springfield team, between the three of us, have almost 75 years of experience in estates, trusts, and wills. And it's our job to help guide you through this process. Additionally, we have with us our guest again, Willie Sheehan, and Willie is also born and raised here in Springfield and continues to raise his own family here. He, along with his brother Pat, worked with their father, Pat Sr., at their law firm, Sheehan & Sheehan. So thank you again for coming and helping with us today. Most of us are familiar with traditional banking services. Checking, savings, IRAs, mortgages. Another great banking service is the trust and estate, is the estate planning that comprises of trust and wills. It is our goal, again, to help you better understand what those tools are and how they are used and can be used to your benefit your estate plan. Whether you're just starting the estate planning process or looking to update your existing plan, understanding those differences are helpful. They may seem similar, the two are very significant pieces and they are different. There are many who fear that if you have a will, you don't need a trust, or if you have a trust, you don't need a will. Sometimes you need both. Sometimes you just need one. Each of your individual stories are as individual as you and I. There are no two alike, and there is no way to write two alike. To help you better understand some of the will and trust terminology, we've created this slide here. In both plans, there are three parties, and each of those parties play significant roles in your document. The first party is an individual with the assets who creates the plan. In a will, that person is known as the testator. In a trust, that person is known as the grantor. The next level of the relationship is the individual responsible for distributing the assets. In a will, that person is called an executor. In a trust, that person is called a trustee. Finally, the third party is the individual who receives your assets, receives your money. That person in both pieces is called a beneficiary. in the, I'm sorry, back to them. In the second layer where the individual is responsible for distributing assets, that person, whether it be the executor or the trustee, that person can be your mother, it can be your cousin, it can be your attorney. It can also be Bank of Springfield, should you designate someone on a corporate level. We'll go to the next slide.
So we're going to be real general here today because part of our feeling is that we need to help educate some of our clients on what they need to know before they go to speak to their attorney, or where do we even begin? Why are they talking in languages we don't understand, and what are these documents they're talking about? So what we'd like to do is just give you a general overview of some of the main pieces of an estate plan. This is the terminology that you want to be familiar with before you go and speak to your attorney. So what is a will? The will is probably the one that we're most familiar with because we've either seen one, we have one, or we've, in some cases, been asked to be executor of one. And if you've done that, you know it, because it's not always that much fun. So what is a will? A will is a document that contains your final wishes for distribution of your property and assets. If you have minor dependents, you can use your will, language inside of it, to nominate a guardian, someone you wish to be appointed by the court to care for any minor children. You can be as general or as specific in your document as you wish when you're creating it. You can leave everything to one beneficiary or charity. And if you remember what we were talking about before, the beneficiary is the party that receives the assets from you. You can split assets amongst several beneficiaries or charities. You can assign specific items to one or more people. You can even name someone to care for your pets and put in provisions on how to take care or provide for them, how to provide the person that you've put in charge of your pets with money to take care of them for the rest of their lives. So there are three parties in a will. We just talked about this, but let's be let's drive it home. There's a testator, the one that creates the will, the one that has all the assets. There's an executor, who's the individual that you choose and put in your document as the one that you want responsible to distribute your assets as directed by the terms of your will. And there's the beneficiary, who is the people, the organizations that are going to benefit from your assets once you're deceased. Your will is the written playbook for your executor to follow upon your death. Your clear wishes that you express inside your will and a properly selected executor help to ensure that your wishes are actually carried out. So what are the requirements to create a will in Illinois? You have to be 18 years of age. I'm looking around. Yep, we qualify. I'm saying that about me too. Documents must be in writing, signed by the testator. Do you remember what that was? Creator. Okay, see, you're getting it already. The testator, the maker, the one that is putting the plan together. The document has to be in writing, signed by that person, and the signature has to be witnessed by two people who aren't beneficiaries. Do you remember what beneficiaries are? People that get the money after you. Okay. Your will should be done sooner rather than later. That's pretty obvious. Sometimes people wait too long. Sometimes you wait until you're not really as quick as you might have been at one time, and maybe that causes a problem with putting your documents together the way you really intended them to be. So do that sooner rather than later. Again, we're going to hit this one too several times. Periodically review your will, especially if you experience life changes. Sometimes the people that you like today aren't the people that you like tomorrow. Document and you die, you still liked them at your death. So you want to make sure that any life changes, after a life change, you review the document. It's not a set it and forget it document. Sometimes we do that. We set it, and we put it in a drawer, and we forget about it. But again, sometimes it's our life circumstances that change, and sometimes it's laws that change that may make it necessary for an update to your document. If you're legally competent, You can change your will anytime before your death. Can't change it after your death. And any changes that you make during your lifetime should be done with the assistance of professional legal help. Right? You can completely rewrite your will and revoke or take away the other one that you had before it. Or you can modify your existing one through the use of a codicil. Codicil is a document that can be created to make changes to your will without the need to completely rewrite it. A codicil isn't a handwritten initialed little note on your original document. Guess what? It doesn't count. If you really want your document to be taken seriously and your changes to really be a part of your document, you need to treat it and modify your original document by using the codicil. You should draft it in the same method that you drafted your original will. It also has to be signed in the presence of two witnesses that aren't two beneficiaries, right?
Disinterested witnesses, correct?
Disinterested. Beneficiaries would be interested. So what happens to your will after you die? We're going to gloss over this. It's a big process, so we're just going to make it really simple so we all are on the same page. Shortly after your death, your will, along with the valid codicils, are going to be filed with the court, and it becomes public record. If you personally own real estate or assets that exceed $100,000, the probate process begins. Probate is a formal, court-supervised process of carrying out your last wishes, resolving any outstanding debts, including taxes, and distributing any remaining assets to rightful heirs. Yes?
Does the will have to be notarized?
Not in the world.
No, it does not have to be.
Just witnesses.
Just two disinterested witnesses.
So are we on the same page with will? Not will Lee. We'll take the next, sorry. Break it up. So now that we understand a will, let's move on to a trust. What is a trust? A trust is a legal tool, a written document drafted by an attorney, which allows you, and we call that you, the grantor, to transfer ownership of your assets during your lifetime to a trust, a separate entity, for the benefit of one or more beneficiaries. The trust document will set conditions on how those assets inside the trust are managed during your lifetime, which includes management during any periods of incapacitation, and will set conditions for management and distribution of your trust assets after your death. Inside the document, you can identify a party that carries out your instructions specified in your trust document. In a will, it was called something else. In a trust, it's called a trustee. The trustee could be an individual, or it could be a corporate trustee, like Bank of Springfield Trust Services. The reason I'm mentioning that is sometimes trust services is a big unknown, and people that go by our department take a look and go, we have no idea what they do, so we're just going to keep walking. We're trying to help you understand that we can be a part of your team, just like your attorney, your accountant, your financial planner. Sometimes people need the services in the trust services area as well. Generally, a trust is created by the grantor. Who's that? The person creating with all the assets. It's the grantor names one or more parties that hold and manage the property. Who's that? The trustee. And that is for the benefit of people or organizations who are going to get the assets that are held in the trust, and they're called beneficiaries. See over there? More of a visual person, so we'll go to the pictures. The little people, grantor of the trust. Those are the people with the assets. The assets are up in the elongated box that has the dashes around it. So what happens is the grantor takes certain assets, cash, could be investments, could be real estate, and they convey those assets into a trust. And again, the trust is a separate entity from the person. The trustee then complies with the trust document that's been written and ends up distributing or managing those assets for the benefit of the beneficiaries who will eventually receive those assets. So why would you have a trust? Well, there's a lot of different reasons, and I'm going to just briefly glance over some of them. They don't all apply. Not every trust does everything. But here are some of the advantages or some reasons why people put money into trusts. Certain trusts can help reduce estate taxes by reducing your taxable estate. Trusts are not reviewed by courts and not subject to court supervision. Since they're private documents, trust documents are, they aren't included in public record. They're not filed at any courthouse. So your assets, your terms of your trust, and your beneficiaries remain private. The terms you include in your trust can be set up for how your money is used during your lifetime and at your death. A trust separates the ownership of the assets from the ability to benefit from them. So in the event that creditors are going after assets, they may be harder to get to if they're not in your name or in the name of the trust. It provides a certain level of control over your assets of your estate, and it allows you to structure how and when distributions to beneficiaries occur.
The most commonly used trusts are the revocable and irrevocable trusts. A revocable trust created during your lifetime allows you, the grantor, to maintain control over those trust assets and make changes while you're living. Revocable means that you can add or remove assets, you can change beneficiaries, and you can even revoke the trust in its entirety if you wish. An irrevocable trust is a trust which cannot be changed or revoked once created. Transferring ownership of the assets to your irrevocable trust must be done with great thought and caution because the trust is binding. Simply said, it cannot be undone. So now that we have talked about the differences between revocable and irrevocable trusts, sometimes the two legal documents can exist in unison within one document. You may have heard the term testamentary trust before. You'll remember that a revocable trust is created during the grantor's lifetime, and a testamentary trust is created by the grantor's will and does not come into effect until the grantor dies. Think of a testamentary trust as a combination of a will and a revocable living trust. Unlike a revocable trust, which is effected during your lifetime and administered at your death, without probate, a testamentary trust is created by your will and only takes effect after your death. So your will, the will directs your assets to be passed through probate and ultimately end up in your trust.
So let's just take a side-by-side look at.
Question.
Sure, sorry.
Could you repeat what you just said?
Yes, ma'am.
Just the last part.
In a testamentary trust, the trust that you're trying to create is built into the directions in your will. But you have to die before your will can actually create the trust after your death. Because of that, all of your assets must go through probate before your trust is created.
So a trust and a will both have to go through probate?
No.
This is a certain type of trust.
Okay.
Sometimes within your will, you create a trust inside the will document. And
Okay,
if that's the way that it happens, the will doesn't take effect until you die, therefore there is no trust until after you die.
okay,
So that's the difference.
okay.
What would be an example of why not?
Yeah.
Maybe, for example, go ahead, sorry.
A common example for a testamentary trust would be for minor children or grandchildren, or any type of trust really can be included in a will. But sometimes a trust may not be necessary depending upon the terms. Sometimes the trust will say if the share of a child goes to a trustee until the beneficiary of the child is age 25, say. But in that case, say that upon death of the testator, the child is 30, well, then there's no need for that testamentary trust, and they just can share outright. But I think one of the important parts here would be to, in this situation with a testamentary trust, in order for a will to have legal effect, therefore thereby creating this trust, giving the will that creates the trust, probate is the process of proving up a will and giving that will legal effect. So without going through probate, that will has no legal effect.
So you kind of have a will, probate, trust, probate, and a testamentary trust that because it's in the will, it goes to probate. Did I say that right?
So if it goes into probate and there is someone that's gonna question that in the probate, when it's in probate, that means that there could be some ramifications, about that going from the will to the trust, if it's gonna go into probate.
I think, wait, are you saying that it could be more obvious, it's part of the record, people can see it, so there may be more of a chance of it being contested?
Yeah.
Yes, that's probably true. But trust can be contested too.
Right. In any event, either a trust or a will could be contested. And in any dispute, of course, the question is, can the person that wants to contest it, do they have standing to contest it? Whether you have a will or a trust, sometimes you just can't prevent somebody from contesting it. That's just the facts of life. You can't prevent somebody from suing you. You can't, always control everything. But what you want in any kind of estate plan, whether you have a will or trust, if you're worried about somebody contesting anything, you want to be sure to have a plan in place so that if they try, their attempts will be unsuccessful in disrupting what it is that you planned.
Would that be in the form of a legal document then? That to try to prevent someone from going after your estate?
Well, yes, that would be just the whole process of completing the legal documents.
And I guess I'm asking, what legal documents are those?
Well, just a will, a trust.
Okay,
Yeah. In Illinois, there are only certain ways that somebody can contest a will or a trust. They have to allege certain facts related to that. It's a high burden to overcome as the person who is contesting one of those documents. But everything leading up to completing these documents is important to make sure that if somebody were to contest, they don't have a leg to stand on. Part of it, not just is an attorney's job to make sure or to advise clients on how they may want to do things or give advice to what types of instruments may help accomplish their goals. But in doing those, it's also important to make sure that what gets done and can't be disrupted by somebody who wants to potentially contest a will or a trust.
In Illinois, what are the parameters of who you can have as your executor? For example, could you have someone that lives out of state be your executor or not?
You can't. The parameters are just U.S. citizen, 18 years of age, cannot be a felon. And I think there's actually legislation relating to the last point there, that they can actually be executor if it's been a certain amount of time, but I won't get into that.
Logistics plays a key into who you select as your executor. Someone living in Colorado may not have the means to come to Illinois and help you settle your estate.
or it may cost your estate a significant amount should you choose someone in Colorado. So those are, again, just deep considerations that are a part of this thought process. Question over there?
Is it successful to put language in the will that should any beneficiary contest the will, then they automatically receive beneficiary benefit?
Oh.
That is a common clause that is used. It can be a deterrent from stopping somebody to do that, to contest, but, you know, it still does not stop people all the time.
So if you, in your will, have that you want a testamentary trust set up once you die, then is that testamentary trust once you die, can that be a revocable trust or an irrevocable trust, or is it one or the other? I mean, it has to be one of them,
It would be an irrevocable trust,
irrevocable.
yes, because at that point, person who created that trust through, so if you create a trust through your will, on your death, that trust becomes irrevocable. Just like if you have a revocable living trust as your primary estate planning document, on your death, usually the terminology would or the clause in that trust would say, upon the grantor's death, this trust would become irrevocable.
Wait a minute. You were talking about if you had a revocable trust, a living trust beforehand, and then you're saying at the time of death,
You
that
can change it after that. It can't be changed.
the revocable trust cannot be changed. So then the living trust becomes irrevocable upon death anyway.
Correct.
Yes.
So the person creating the trust is deceased.
So you're not around to change it and nobody else can change it. It's set at that.
So then the beneficiary of that trust though, what happens to them? What happens if they're wanting to provide upon their deaths? I mean, what happens then?
Ultimately, it depends on the terms of the trust. There are many different things that you can do. And so, for instance, your trust could provide, give the right of one of your children to live in your real estate during your lifetime, or during their lifetime. And you can, in your trust, give that child who can live in the house, you can give them then what's called a power of appointment, to allow them to then determine how that piece of, how that asset, that piece of real estate then is distributed upon their death. But you know, there are a lot of ifs, ands, and buts related to this topic. So hopefully that answers your question to an extent, but we could probably talk about this for days.
It seems to me like when you had the choice of setting up a revocable or an irrevocable trust, that you could change it during your lifetime or you can't change it. Whichever one you have upon your death, it sounds like both of them become irrevocable.
The irrevocables that we were talking about in that slide that was the revocable versus irrevocable are always irrevocable. Like they are set up to be irrevocable. And sometimes for specific purposes, you set up an irrevocable trust and it can't be changed because it's fulfilling a specific need. Thinking about
Medicaid.
right. So under certain circumstances, you would choose to set up a trust during your lifetime that can't be changed. That's an irrevocable trust. Does that make sense?
Well, and I don't know farm ground being passed on from generation to generation might be something completely different. But if you have the grantor wants to set up that the farm will pass down to the next generation, and they do that as a living trust, a revocable trust. Okay, so once the grantor dies, the beneficiaries named in that living trust get the farm. Does that trust continue on there? Because now you're saying the grantor died, it's irrevocable. The beneficiaries that received the trust or the benefits of that trust, how do they go about then managing it, passing it on to their heirs or whatever, if it becomes irrevocable upon the original person's, am I making sense? You know, it doesn't.
You're making sense. And who manages it? The trustee, the successor trustee. Generally speaking, for a revocable trust, during your lifetime, the grantor is the trustee. And then upon their death, the trust document would appoint a successor trustee. With farm ground, that in and of itself is could be a day or two long seminar.
Okay.
But commonly, there are, different factors. I think Greg had mentioned there's usually one of the children that is a farmer or part of the farm operation, and two that are not. And so whatever the grantor's purpose of their trust, what they want, would dictate how that farmland is distributed. Whether it's distributed outright to the beneficiaries with the farmer sons or daughters' ability to purchase that farm from the others, or that trust could continue on for a period of years, or could continue on for the beneficiary's lifetime with the right to farm it. So there's so many different things that could be done.
So it's not like then at the time of the death, with the will, when the trust, if it's set up as a revocable trust, now becomes the irrevocable trust, the beneficiaries of that trust, then once they receive it, it cannot go about rechanging it or something that will then go forward, like for their heirs and stuff.
The beneficiaries are not allowed to rewrite your document. They're just a beneficiary receiving the assets from your document. They would create their own.
Okay, so a whole new trust based on the trust that you
level.
inherited.
Yes, maybe if that's what they chose to do for their level. You have an opportunity to write your document. If, for example, you have a daughter who has children and you want your farmland to stay with your daughter and within your family with each generation, you can write those rules in your document to direct that farmland be passed to that lineage.
And would that original trust still stay throughout the many generations, or once the next generation gets it, then a new trust has to be made to continue on?
Ultimately, it just depends on the terms of the trust. The main question is what are the beneficiaries inheriting? Are they inheriting a lifetime interest that upon their death goes then to their children? Or are they inheriting a share of the decedent's estate that they will then own outright as their own asset? And
Which they can do with whatever.
in that case, then their own estate planning documents would dictate how, it would be distributed on their death.
So if we look at this slide, it's going to tell us a couple of interesting facts. One from the will's point of view, one from the trust's point of view. A will requires probate administration, a trust does not. A will is probated as a public process, the trust is private and not filed with the court. You don't manage assets really by a will during a period of incapacity, because it takes effect at your death. So if you're incapacitated, the will can't do anything for you. There's another way to do that, but just thinking about the will document itself, you can't really handle your own incapacity into a document that doesn't take effect until you die. So if you're still alive, but you can't function to take care of any of your financial affairs, the will's not really gonna get you anywhere. But in a trust, you can manage assets if you're incapacitated by putting the language in the trust document that says who's responsible for helping you, or what happens to your money during the time of incapacity. And the trustee would be responsible for making sure those, that you were taken care of according to how your document specifies. You can't really manage assets while kids are under age 18 in a will, because you leave the money to a guardian who takes care of the money for the child. But you can manage assets for kids while they're under 18 and beyond that in a trust document by putting the correct wording in there. Most of the time, wills might be less expensive to draft because they're, as we've already talked about, there's like a lot of different things you have to flesh out of the trust, but it might be a little more expensive on the front end, but it could save you money on the back end as you're distributing your assets to beneficiaries the way that you really want them to be done, and not all at one time, or you know, using some different techniques that are available inside a trust and not inside a will. One of the more important things is the asset collection. If you're collecting assets at the time of someone's death, it's not the person who owned the assets that's doing the collecting. So unless the person that owned the asset leaves really good notes or shares information with someone else, sometimes it's a process of trying to find the assets, and that can be very time consuming. In a trust, your asset collection might not be necessary if you fund your trust correctly and the assets are already in the trust in the first place before you die. So sorry.
In addition to the will and or trust, there are some additional documents that are truly your next important documents to have. A living will is a document that outlines your preferences for medical care and should you become incapacitated. It expresses the guidance, gives the guidance to your loved ones and your medical team on your desires for life-sustaining treatment, pain management, and your organ donation. The next most important document is your healthcare power of attorney and your power of attorney for property. The healthcare power of attorney is a person you trust to make your healthcare decisions if you are unable or unwilling to make them. Power of attorney for property ensures that your financial decisions are handled properly when you can no longer make them for yourself. All of these documents pass when you pass.
Just real quick as an aside there, all of these documents fall under the umbrella of advanced directives. Another one is do not resuscitate, DNR, that you would fill out with your physician, your primary care doctor. But when it comes to the difference between the healthcare power of attorney and a living will, healthcare power of attorney appoints somebody to make decisions for you. You have an agent, and likely within that document you have successor agents named, someone that will be talking to your doctors and other healthcare professionals on any major decisions related to your healthcare in the event that you're unable to do so on your own. The living will is pretty much just a one-page piece of paper that gives, which is the language about life-sustaining treatment on the living will is included in your healthcare power of attorney. But practically speaking, if you have both a living will, which is just a one-page document giving guidance to your doctor, and you have a healthcare power of attorney, practically speaking, the doctors are gonna be talking to your agent under the power of attorney and have them make a decision. So on this topic, it's important to have those discussions with your loved ones or the people that will be appointed in these positions about what it is that you want in these situations regarding life care or life sustaining treatment.
Again, just today, it's obvious the idea behind a trustee will can go in so many different directions. And each are based on your needs, your expectations, and your desires to plan for your family after your death. The two trusts that we focus mostly on today were the revocable and irrevocable trust. But there are several more, and they address each of the unique aspects that can become a part of your lives. There's a special needs trust for special needs children. There's a charitable giving trust. There's also a life insurance trust. Each of those being unique are discoverable upon a conversation that you have with your attorney or your estate planner. When meeting with your attorney, we have learned that organization is key. Setting aside time to plan and think about your wishes before that meeting will only help your attorney help you and help you help your family. We have created, and again prepared, I think Greg had shared earlier, the financial organizer that's in your folder. Earlier this week when I was speaking with Pat Sheehan Sr., he stressed the importance of setting aside features in this process. He felt that so many people start this planning but stop because they don't know how to get started. They don't know how to begin and push aside their worries and burdens. Hopefully this organizer can help you alleviate some of that and begin this process sharing your thoughts.
So I just wanted to mention briefly before we go to a period where really can talk about anything that he wants to talk about. We just want to make sure that you're aware that Bank of Springfield has a trust services area and that we are here to help you in your plan if you need us. If you don't need us, if you name people in your documents that are your executors and you have that all covered, great. But there's a lot of people that we've talked to recently, especially, that either don't have anyone in their family that they want to name as their executor or their trustee of their trust, or they have situations where their families have left the area and they don't have anyone local, and they really don't want to burden someone with the task of going back and forth and trying to figure out an estate in a different state. We can serve in capacities for you as executor, as trustees of some of the trusts. We can be a backup person to the person you name in your document. So if you name your friends or your family members and they can't or choose not to serve, then we could be in line as well. So it would be sort of a fallback plan in case your previous people don't work out. Sometimes things happen and executors die before you do. And maybe you don't realize that and your document is in place and all of a sudden you don't have a backup plan. So we would be willing to be inserted in your document and be your backup plan as well. We've included a lot of different documents inside your folder for your benefit. We're not going to go over those or talk about it today. But take a look at them. The personal planner that Beverley was talking about is really thought-provoking when you start looking at it. There's lots of different things that you probably haven't even thought about that if something happened to you, your family members won't even know how to get to. So we bring up some of the digital assets, some of your pictures that are online are stored in the cloud somewhere that you don't even understand how they get there. And you're not sure how you access them, but your family doesn't know how to access them. If you die, what happens to those? Can someone else get them, get to them? So we've included those in the document as well so that you can start thinking about those types of assets as well if you have them. So we just want to be part of your team if we can be And we want to be a resource to you when we can. We've just decided this is a great topic because we do have so many people that stop by our offices and say, hey, I don't know the first thing about where I need to go. I know I need something, but I don't know what to do. So we decided that it'd be a great idea to bring in an attorney that is well versed in that topic and let them tell you what they need to know before you come in, or how you can prepare to talk to them and how to use their time the best. So we'll turn it over to Willie and let him specify more detail on any of this stuff.
Thanks, Kim and Beth. Just to real quick piggyback on the value of a third party or corporate trustee or executor. The corporate trustee, you know, if you have Bank of Springfield or serving as executor or trustee, you know that it's going to get professionally done from beginning to end. What needs to be done will get done. If you think about your own family, most individuals have never experienced having to serve as a trustee or executor and don't know where to begin, or may have only done so once or twice. Professionals such as Bank of Springfield Trust Department certainly would know exactly what to do in probably any situation that would come up. Corporate trustee also won't be influenced by beneficiaries of the trust. There may be a trust that's set up for a child, a beneficiary of the estate, or a trust that doesn't get to control their money. They're just receiving monthly or annual income, or however it's set up. And a lot of fears that people have is, I don't want to burden any of my other children with having to deal with them. Whether that's them being pushy about getting their money or demanding, but that's something that third-party corporate trustee will not really be influenced by. Bank of Springfield also has the capabilities of the investment division, and then also too that with a third-party corporate trustee, the terms of your trust or the terms of your will get followed as they're written in the document as you intended them to. Overall, though, it's important to just get something done. It is a very difficult topic for most people. Who enjoys talking about death? I'm used to it. I don't really enjoy talking about it. I talk about it every day. So, but a lot of people, that's the hardest thing. I can't tell you how many times people say, I've procrastinated on this for many years, and it's time I need to get something done. Sometimes what pushes them is they experience whether someone in their own family or a friend who passes away without a will, or without proper planning for a special needs child, or something to that extent. And you see then firsthand the issues that it causes for their loved ones. That your family's already in a state of grieving, hopefully with your passing.
Celebration.
But having to navigate more than they need to, they should or should have to, they'll never forget that you did have it all planned out. If you get this done, so it does not have to be complicated to be effective. Sometimes the simpler the better, and I can't emphasize that enough. In really failing to make decisions, failing to get things done, can just simply make post-death life for your family ripe for disputes for whether that's just amongst family members or contesting wills and whatever. of course, it's always, not always, but it certainly can become well, mom said she wanted me to have this, dad said he wanted me to have that, and, well, it's not in writing, so legally, you would like everybody to get along, but it certainly does not work that way. I think a lot of times, most people are surprised. Once they're done, they're surprised with how easy it was. So if you can just get over that hump of getting something done, getting the process started, I think you'll be surprised that it's not as difficult as you maybe anticipate. So with that, ready to open up for some questions if. Yeah.
If a will doesn't specify certain items go to certain beneficiaries, but there is a letter of instruction signed by will's creator, does that really hold any weight?
It depends. If the will specifies a document as you're speaking of, then yes, that document would hold. But if it's something that was done after the fact, it would not. If it's not referenced by the will and incorporated into the will by that reference, then it would not have any legal effect.
So what would an executor do in a case like that where it's not a part of the will, but it's on file?
Well, if that is something the executor finds, it depends on the situation, of course, as I could probably say for every question. But the executor could simply say, hey, to talk to the beneficiaries and say, hey, I found this letter. We know it doesn't have legal effect, but we very well know that this was done by the decedent. You could just try to get an agreement put together amongst the beneficiaries of the estate and see if they honor the wishes of the decedent. But in most cases, that's not that easy.
So what Willie said before, take care of it now. Put it into the will that you have a document that says you have specific wishes. And then make sure that that document stays close to the will so that it can be discovered as well. Bridge the gap.
Right.
On just some ballpark figures, how much does it cost to have a trust prepared?
Well,
It
depends. Well, so Craig and Bev and Kim all talked about part of the process of a trust is retitling asset. In order for the trust to work the way it's intended, you will need to retitle some assets. And so that's part of the process. The trust document itself is usually a more intensive document than a will would be. But, ballpark, it could be anywhere from 1,500 to 5,000. It ultimately just depends on the amount of time, and I'm not saying that's what I would charge, I'm just saying it depends on the amount of time but yeah, to retitle assets, but there could be a lot of conversation back and forth amongst the attorney and the client that could necessitate in several office visits or phone calls. But most attorneys charge for their time on an hourly rate, so. Yes.
If all your banking and your, house, if all that is put into your children's name when you die, is a will or a trust necessary?
Well, touch on a good topic of, so a couple things related to that. First, putting your children entitled to your real estate. I would never recommend that, for a few reasons. One, when you do that, you can't do anything related to your house so you can't take them off without them agreeing to that. You can't get a loan on your house or a second mortgage without them signing. And you may, of course, not want them to know any of that. Two, when you add them onto the property, you're making a gift to them. And thereby making that their asset as well. So you're then making your house subject to their creditors. Now, they may not have creditors, but tomorrow they could if they're at fault in a car accident.
Even if it's on your desk?
What's that? I'm sorry?
Even if.
Oh, even if this is so you're at your death, you're transferring it to your children.
Right.
Okay. So in that situation, your will or your trust is going to govern how those assets are distributed. The executor or the trustee's job is going to be to collect all of the decedent's assets and then pay the final bills, and then ultimately distribute the assets according to the terms of the will. So generally speaking, with real estate, the house gets sold. Or there could be, and the net proceeds from the house are distributed to the terms of the will. You could also specifically bequeath real estate to one of your children. Does that answer your question?
Well, sort of. But, so you're saying that even though the house goes to them on my death, if they have financial problems now, it could go against my property?
Well, so I misunderstood your question.
Okay.
And thought that you were asking that if you were to add them to title on your real estate while you're living.
Okay.
Okay.
Okay. Thank you.
Yes. What Kim asked is, what about the estate not having any funds to settle the estate in the event that you have either added your kids onto a bank account or beneficiary designated everything. So important rules to know here are, if you have beneficiaries designated on all of your assets, those will go directly to your children. So then whoever the executor is, they're going to have no money to pay for real estate taxes, maybe a mortgage payment, insurance, utilities, maintenance, lawn maintenance, final income tax returns, all kinds of things. So yes, you think, oh, well, yeah, they're going to get money from the beneficiary designations. But if you have more than one kid, person that's taking charge and doing all that stuff, whether that's your executor or the person you've named as your executor, they may have to pay all that stuff out of the money they receive, and they may not get contributions back from the other 2 or 3 children that are receiving something. So it's important, while I understand in some cases, some particular assets, you definitely want beneficiary designations on, like IRAs, for instance. But I always will recommend to clients that they at least leave some money for your executor to pay for your funeral expenses and give them a little nest egg to do what they need to do to liquidate your assets to then distribute to everybody.
How do you do that so that they have money in hand when, pretty quickly?
Well, when somebody dies, the bank may put a freeze on the account, whether they see the obituary or somebody calls in and says the account holder's died. But getting access to that account generally isn't a difficult process as long as you have a death certificate. usually once you, the death certificate. So as soon as you have the death certificate, you can generally get to the bank or getting to court to get, if the will needs to be probated, then in that situation, it's not difficult to get the estate opened. In Sangamon County, probate's 4 days a week. In Sacramento, they come the day before. And, but if there's a trust, of course, then in that situation, depends on the bank account is in the, titled in the name of the trust. But there are, it depends on just the sizes of counts, and the estate planning documents that the decedent had. But ultimately, there shouldn't be a long period of time where they can't get access to the funds. Once they have the death certificate, they should relatively then be able to get it.
Would there be an estate account set up then to handle further estate expenditures and or income?
That would only be the case if the will was being probate and there was an estate officially set up through a probate case. And in that case, you would get a tax ID number for the estate and then set up an estate bank account that would you would conduct all your business, all the estate business through. And the same procedure would happen if you had a revocable trust. Upon your death, it becomes irrevocable. Successor trustee will need to get a tax ID number for that to handle the administration of the trust. Yes.
In Sangamon County, how long does it take usually for the will to be probated?
So in Illinois, if you are probating will, it's required that the estate stay open for a minimum of 6 months. But generally speaking, that kind of can depend on when the death of the decedent is, because there's always tax returns that will need to be filed. Final individual tax return, there may be an estate income tax return that has to be filed. So sometimes I think it depends on I've definitely had estates that are done within 6 or 7 months, but and we can close it within then. But other times it's necessary for it to stay open a year just because of the timing of everything with tax filing.
While you're still alive, what would be some examples why someone would do an irrevocable trust?
Irrevocable trust. The most common reason you'll hear and see is for Medicaid planning or for nursing home planning. You'll hear ads on the radio or on TV about setting up a trust so the nursing home can't get your assets. But that of course sounds too good to be true, and it is based on those ads. They're very misleading because at the root of that, what the person is doing here, they're essentially transferring their assets to an irrevocable trust so they are eligible for Medicaid. So there's Medicare and there's Medicaid. Medicare is for individuals 65 and older. Medicaid is for the poor, and it's based on income and assets. So if you transfer your money into an irrevocable trust, you lose control over it, and that transfer is subject to a 5-year look-back period. So even if you see the writing on the wall, think I can't live on my own much longer, nursing home is not too far in my distant future, I want to transfer all my assets into an irrevocable trust, well, you're not going to be eligible for Medicaid for at least, well, depending on how much you have, but you're not going to be eligible for Medicaid right away because they're going to look at how much money you transferred into the irrevocable trust and determine your eligibility for Medicaid based on that. But they would be able to look back. They're going to ask, when you're applying for Medicaid, they're going to ask for any assets that you've owned in the last 5 years and question any transfers that you've made.
Is a prepaid funeral considered an asset that would be considered under those circumstances?
You can, it would not be, because one of the things they'll suggest doing to get eligible for Medicaid, they'll say, go prepay your funeral. Well, there's 15, 20 grand out of your account and you're closer to eligibility. The common term there is spend down. Spending, someone has to, in order to be eligible for Medicaid, they have to spend down their assets. And buying a funeral would count towards that spend down. Paying for that, yeah.
We do have one question from online. They asked if they could explain the use of per sturdies.
Sure. So often you will see whether in a will or beneficiary designation forms, the term per stirpies. And so what that essentially means is that so for instance, you can say 50% of my estate to my daughter Joan Smith and 50% of my estate to my son John Smith, per stirpies for both of them. So if John Smith predeceases the testator, then John Smith's 50% share will pass to his descendants. So per stirpies follows the line of descendancy without naming the people.
The opposite of that is per capita.
Correct. So if it's per capita, then that bequest would lapse, and then in that example I just used, Joan Smith would receive 100%.
So if Joan had 5 children and John had 15 children, isn't per stirpies these 5 children get the same amount? Get $1,000 and these 20 children get $1,000.
It would be, so Joan's share per 50% would go 5 ways to her children. John's 50% would go 15 ways to his children. Yeah. So
Then probably children have
Right.
still get the same, yeah, and then per capita is, consider that in terms of
yeah,
children.
per capita, it would not get past the person named. That share would lapse and the Joan Smith would get all of it. So, but if you didn't have per stirpies and there are 2 people and they both predeceased, well, then what would govern is the intestacy statute, if you didn't have any contingent provisions.
There can be co-executors of the will. Can or should there be co-trustees or successor trustees?
There can be, and I generally do not recommend co-executors or co-trustees in most cases. Just because it could, if they don't agree on something in the future, it just could create a mess for the entire trust estate or the entire estate.
Thank you, Joan. I'll turn it back over to you.
Lynn and I would like to thank our panel here, of all of our speakers. They put in a lot of time developing the information and taken their time to come and present this for the Classic 50. And I'd like to thank them for doing that. Thank you. And the Classic 50 program has just come back to Bank of Springfield and trying to develop it with more topics like this. to help people understand different banking needs, as well as our travel, which are day trips, overnight trips, and long trips. So we're trying to get a well-rounded program that can fit all of our class of 50 people. So we want to thank you for coming to our seminar today. Thank you very much.
You're welcome.